Hi, and welcome to the AAHOA Educational Experience. I'm Chip Rogers, and this week we're talking about labor relations and some of the issues going on with union organizing and what you need to know about it. My guests this week include Sal Sameo from the Ford and Harrison law firm. You've been with us before. Thanks for being here, Sal. And to his right, Jacob Monty, who is a managing partner with Monty and Ramirez law firm out of Houston, Texas. Gentlemen, thank you both for being here with us. You are experts in this field. Let's jump into this. I've heard this acronym before, the FLSA, and it stands for the Fair Labor and Standards Act. If I'm an employer, what is it I've got to know about this?
Well, you got it partially right. It's known as forever lost and seeking answers. And the reason is the law's been around since 1948 and people still get it wrong. The law covers, it's your traditional wage and hour law, so it's the bare minimum what employers need to comply with. And it deals with minimum wages that you have to pay your employee. Currently the minimum wage is $7.25, and overtime, and what constitutes overtime. And then it deals with who is exempt from overtime. The first thing is everyone is covered by the overtime law. When the law was passed, it was in the 40s, so you needed to have an annual dollar volume of $500,000 a year. Now in 1948, that was a lot of money. Today, not really. Right. And you needed interstate commerce. Well, back then, you can operate in one state and be fine. Nowadays, you have credit card machines, internet, telephone. It's impossible to operate just in one state. So it covers everyone, which switches the burden to the employer. So now the employee, all they have to do is make an allegation, and now the employer has to prove that their employees are either exempt or that they maintain their records properly or they paid their employees properly. That's why the plaintiff's bar has switched from suing for discrimination and really going after these wage hour type of cases. It's easier money for them. There's mandatory attorney fees, and the benefit is the burden is on the employer to show they didn't do anything wrong. So plaintiffs have been filing, and plus they're class actions. And one of the things about wage hour litigation is that during discovery, early on in the case, the plaintiff's attorney gets your payroll records. Once they have your payroll records, it's a fishing expedition for other violations. So, and state laws have become overly broad, and you have triple damages in some states, you have meal break laws, and there's a bunch of other types of laws that have come through and wage hour now, and states have expanded upon, which have increased employers' liability. So this really has been the hot issue in employment law for the last, 5 years, and it's growing every single year. The last 2 years, the hottest issue has been independent contracting.
And I understand that both states and, of course, the feds are really cracking down on that because from an employer standpoint, independent contracting is so easy as opposed to having an actual employee.
Right. Well, there's two big initiatives that are out there. Right. The first is the DOL knows that it's easy to go after independent contracting issues. And states are hurting because of the unemployment rate. They've lost a lot of income tax. So the Obama administration came out with this thing, which basically has states compete against each other to see who can identify the most misclassified independent contractors. Whoever does gets additional federal fundings. So if you're a state, even a conservative state like Mississippi or Kentucky, if you go and find people who are misclassified, well, now you're getting back taxes for unemployment, workers' comp, and income tax, plus you're getting additional money from the federal government. Also, what we've seen in recent years that never existed before was the cooperation between government agencies. Right. So if the DOL finds a violation, they report you to the IRS. If the IRS or a state agency finds a violation, they report you to the DOL. So it's become a really hot issue. The DOL's current initiative is against temp agencies. So they know that people that are hiring temp agents, people from temp agencies, are probably joint employers with those people. Most employers hire temp agencies because they don't want to deal with the problems with employees, right? So you go out and you get a temp agency, you have your employee, the temps working there, they're not your employees until the DOL comes in and finds a violation. Then they say, well, they're your employees. So, and they've even taken it a step further where this dealt with gas stations, but where they found franchisees or distributors, exclusive distributors of a product, where the parent company who was producing the product and then sold it to their distributors didn't have any violations, but their distributors did. So when the DOL came in, they said, look, your distributors are in violation of the law. We know they can't afford to pay it because they're seeking millions of dollars. So we'll put you in the press release and, basically hit you in the press as saying these are your exclusive distributors unless you pay, the money. Wow. So they've been using the press, they've been using a lot of new techniques under the Obama administration. They've been now I worked for Clinton and Bush when I was at DOL. During the Clinton administration, Bush administration, the way the DOL did business stayed the same. Priorities changed, policies changed. The Obama administration has changed the way the DOL does business. They've changed the enforcement mechanisms and how the DOL does business. It used to be complaint driven, where people will call in and complain.
Right.
Now, the majority of complaints that are coming in are being sent to private attorneys, and they're using what's called directed investigations. Directed investigations means they're going after either industries, employers, or certain positions as targets of their investigation. This year, the industries that are being targeted are home builders, landscapers, janitorials, and hotel industry. They started out in Tennessee. It was extremely successful. So now they've broadened it nationwide, and they're going after specifically the hotel industry.
So Jacob, if I'm a hotel owner, and I think I'm doing everything right, what is it that I really need to make sure I've got myself covered on? What's the one thing that hotel owners get burned on that they're probably not thinking about?
Well, the most common violation that comes up is paying the housekeepers by the room versus by the hour, and that's something that Department of Labor is savvy to. Unions try to make hay over it as well, and just making sure that the way you're paying complies with the wage and hour laws. So
the practice of paying by the room as opposed to paying by the hour is not acceptable.
Right. And
yeah, I mean, you can. It's permissible to pay by the piece rate, but you still have to include an overtime component in there,
right.
And that's where many employers don't understand that. They have a piece rate for the housekeeper, but it doesn't take into account time and a half for hours worked over 40. That's the biggest violation I've seen.
So to the average viewer of the show, or to someone who's not familiar with this would seem like a very minor infraction, but what's the potential liability in a case like that?
No, it can be huge. I mean, when when they're cleaning per room, depending on the amount that they're cleaning per room, you get hit with two things. You normally get hit with minimum wage, you'll get hit with overtime, and then you'll get hit with civil money penalties, which are $1,500 per violation. They look at each work week as a separate violation. So it could be huge. If you have any government contract work, or you accept government contracts, then there's a potential that you could even get debarred. Other potential violations deal with if you're charging excessive rates for room and board for your employees and deducting that from your pay. If they're doing pre-shift or post-shift work that they're not getting paid for. If you're deducting meal breaks from your employees and they're working through the meal breaks, or they're not taking the full amount of time for the meal breaks. So there are a lot of issues. And then the other thing are temps. A lot of hotels are using temp agencies. A lot of time these investigations are actually started by temp agencies. The DOL will go out and investigate a temp agency that deals within a particular industry, get their records, and then go after all of their clients. So temp agencies are a gateway into the hotel industry, but they're also doing directed investigations where they're going after specific hotels in every region.
Right.
So.
Chip, another problem that I've seen is, there's an old saying, no good deed goes unpunished. Well, many hotel owners or operators accommodate the employee and make him a salaried employee even though he's not exempt. And Jose comes to you and says, hey, in order for me to work here, I want $600 a week, and I'm going to work 6 days and no overtime. That's our deal. That's the arreglo between me and the owner, and everything's fine until I get mad at the owner or Department of Labor comes down, and there can't be an agreement between the company and the employee to deem you exempt if you don't qualify.
Right.
And Sal can tell you that the limit, who's exempt is a pretty finite group of people. It doesn't turn on what the agreement is.
And before we got to take a break before we go to that, but we're going to talk about that. This is some good stuff and some interesting information here that you need to be made aware of. So make sure to be with us right after the break. We'll come back after this. Welcome back. I'm Chip Rogers. This is the AAHOA Educational Experience. We're talking about labor issues, specifically dealing with Fair Labor and Standards Act and some of the potential violations that you as a small business owner may in fact have. My guest again this week, Sal Sameo from Ford and Harrison, thank you, and Jacob Monty with Monty and Ramirez. Thank you, gentlemen, for being here. In the last segment, before we went to break, we brought up this term of an exempt employee, and this just hearing you talk about it tells me my red flags went up that this is something that we need to know so we don't get ourselves in enormous amounts of trouble with the Department of Labor. Explain what an exempt employee is.
Okay, so before I explain exempt, I just want to pick up something that Jake talked about last, and that was agreements. The Fair Labor Standards Act is one of the unique laws that does not allow an employee to release their rights under the law. So even if you pay your employee, you say, oh boy, we got a problem here, and you give them $1,000 and say, look, here's the money I owe you plus $1,000, sign this paper saying that I don't owe you anything. It doesn't matter. It doesn't matter because the DOL can come in and still find the violation. The plaintiff's attorney could still sue. So as I said before, most employers, almost every employer in this country is covered by the Act. There's something called an exemption, and the exemption under the law is known what is an affirmative defense. What that means is not only you have to plead and prove the exemption exists. The exemptions are very narrowly drafted. When the exemptions were initially created in the 40s, they were to cover the people that were running the company. So basically it was the managers and CEOs, they were exempt employees, then you had administrative employees. Now administrative employees are people who aren't really managing other employees, but they have high level functions. Maybe it's the PR person, the CFO if they're dealing with financial issues but they don't have any employees. So that was the other exemption. And the other one's professional, if you're a lawyer or a doctor or an accountant or you're relying on some sort of degree. In the hotel industry, except maybe in the corporate office, there aren't a lot of exempt employees. So anytime you're paying, now you can pay people on salary, and sometimes it makes sense to pay people on salary, but you have to know how to do it the right way.
Right.
So if you pay someone on a salary, what I would recommend is having your employee sign a document saying that they're receiving a salary for all hours worked. So, and what this does is it actually reduces the overtime rate, because then after 40 hours, you still have to pay them time and a half of their hourly rate. But how do you determine what the hourly rate is? You take the salary and you divide by the number of hours they worked that week. So if they worked 45 hours, their rate's going to be higher than if they worked 60 hours. The more hours they work, the lower their rate goes. And since you signed a contract with them that they're receiving a salary for all hours worked, you only have to pay them half time, not time and a half, because they've agreed to receive that amount of money for all hours worked. So what you do is you would take, let's say they work 60 hours. You take 60 hours, you divide it into their salary, whatever the agreed upon salary is. Assuming it didn't fall below the minimum wage, which is $7.25, you'd pay them half of that rate for every hour over 40, and that complies with the law. So there are ways to pay employees salaries and still comply with the law, but you have to really look at what you're trying to accomplish and look at the requirements of the law and comply with it. So exemptions are the employer's duty. Just because someone says they're exempt or you say they're exempt, you have to prove it, which is very difficult.
Like you said, the burden of proof is on the employer.
It's on the employer, and you have to show what they do, I would say the majority of the week. So if you have this, I'll give you an example. Let's say you have a supervisor or supervisors, 2 people. One person goes out on maternity leave. Well, that person is not exempt during the weeks that the person's on maternity leave because they're only supervising one person. What if they're supervising one full-time and one part-time? Well, the law says in order to be exempt, you have to supervise at least 2 people all the time. So in order to meet the exemption, you need the equivalent of 2 full-time people. So that's 2 full-time is 4 part-time, or 1 part-time and 2 part-times and 1 full-time person.
Right.
So the exemptions are hard to meet. You really should sit down with an attorney and figure out who you want to be exempt and how you're going to get them exempt. The other thing about the FLSA is it provides for a good faith defense. So if you go to an attorney and say, listen, here's the way I'm running, here are my positions, this is how I'm paying people, is this accurate or is this not accurate? And the attorney provides you with an opinion. They can help you perfect what's called the good faith defense. And what the good faith defense does, the statute of limitations in wage hour cases is 2 years, it could be 3 years. The good faith defense will eliminate the 3rd year for back wages, right, and it'll cut your damages in half if you're found to be liable.
If you've got one of these problems, you need to go to an attorney who understands this so that they can begin building that case.
You should go to an attorney before you have a problem. Because
Well,
as long as you're in compliance and you maintain compliance, you're never going to have a problem. Knowing that the DOL is targeting the industry means that the plaintiff's attorneys are targeting the industry.
Right.
Because the DOL will go in, they'll create a record, and then the plaintiff's attorney are smart enough to know that under the Freedom of Information Act, they can write into the federal government and get that file. They'll get the file, review it, and they'll file a state law action.
Right.
Federal law is, the U.S. Department of Labor only enforces the federal law. So they'll pick up on that and file a claim under the state law to get additional damages. It's easy money for them. So it's important to kind of get your house, knowing that the industry is being targeted this year, it's important to really get your house cleaned up now. And the easiest way to do it, of course, is to pay people minimum of $7.25, time and a half that for all hours worked over 40, and all hours worked means all hours worked. So let's say somebody comes to work and they're supposed to leave at 5 o'clock. They punch out and their friend wants to go to a game or something, and he says, hey John, I want to go to the game, but I can't leave until I finish this. Come here and help me. He says, okay. So he goes there and helps him out. That work has to be compensated for. There's no volunteers under the FLSA. You can't volunteer. So there's no such thing as a volunteer or an intern. Everyone must be paid for their work. So,
a moment ago, or in a previous segment, we talked about contract labor. Some people call it 1099 labor. And this has become a major issue. Jacob, if you will, help us with this, because there's always been a confusion over what actually constitutes contract labor, and at what point does that person who may legitimately be working contract labor cross over to become an employee?
Well, let me say that whether you're an employee or an independent contractor is determined on a number of tests.
Right.
But generally, you can't have independent contractors clean your rooms or work in your restaurant. An independent contractor is going to be that plumber who comes in and works on the drains, or that outside painter that paints the hotel. It's not going to be someone that comes to the hotel routinely or on a daily basis to perform work. That dog just won't hunt. Essentially and each test is a little different, but they do turn on control. How much control do you have over the person? If you have a lot of control, they're going to be deemed an employee. If you have very little control, they could be an independent contractor.
How do you know, though, when someone has been doing legitimate contract work for you? At what point do you say, we're getting a little close to the line here, and maybe they are, in fact, an employee now? I mean, is it when you begin directing when they're there? What are the criteria?
That's not an easy question, because there's different tests under different laws.
Right.
But let me answer your question by telling you how it's investigated. Okay. So how does the DOL, when they come in and they're looking for independent contractors, what do they look at? They look at two documents, your 1099s and your cash ledgers, okay? So who are you paying in cash on a regular basis, and who has a 1099? Then they look at, does the person have an EIN number, right? After they see the EIN number, they do something very simple. They Google them. If it's a legitimate company, they'll probably have a website. If they have a website and it looks like a legitimate company, they write it off. If there's a social security number, you're flagged, okay? And they'll call the person, they'll send questionnaires out to those people requesting information. And then they'll make the determination, are you really an employee? Who else are you working for? Do you work for other companies? Are you advertising? Do you have business cards? Do you just work for this one employer? Do you work for two employers and their sister companies? What's your relationship with the company? That's what they're going to look at. So if you're an employer, what you should do is take out your 1099s, take out your cash ledgers, look for reoccurring payments in the cash ledgers going to individuals, look for social security numbers on your 1099s, and say, who is this person? And then ask them what the DOL would ask. Who else do you work for? Do you advertise? Even if you just use and I'll give you a real example to send it home. I had a nursing home client who hired a doctor, and the doctor went in and gave care for a week, a month or something to his patients at the nursing home. Well, apparently the doctor received a lot of income from other investments and didn't really have any other job. So when the DOL came in, they said, well, the doctor's your employee. The company said, well, what are you talking about? This is a doctor with his own practice. We just hired him to take care. But on the face of the records, It was the only employer he had, and they determined that he was an employee. So even though it's ridiculous, it could happen. So when you're dealing with 1099 employees, the first thing is it a corporation? Do they have an EIN number? Do they advertise? How are they holding themselves out to the public? Are they employed by other people? Okay, that would be my approach if I was an employer. Do what the DOL would do if they came in. And if you're not sure what they would do, then you can hire an attorney to help you figure it out.
Well, that was a wealth of information. I felt like I was drinking from a fire hydrant. It was good. It was very good. We're out of time for this show, but we've got another show next week on this subject and a lot more information you're going to be interested in. So for Jacob Monty and, of course, for Sal Sameo, thank you, gentlemen, for being with us again this week. I'm Chip Rogers, and if you'd like to contact me, you can do so. Email is chip@ahoa.com. That's chip@ahoa.com. Until next week, so long, and we'll see you again.